All right, I'm going to go ahead and get started. It's 12:59. 12:59. Yeah, 12:59. I'll be darned. Hi, Serena. Anyway, thank you all for being here today. I'm going to go ahead and get us started. And the way that we're going to do that is I'm going to pull up the. All right, I got to pull up the screen share. Where is it, Linda? I always ask for Linda because usually she knows where everything is, and I can't see anything right now. Okay, here we go. All right, so let's go ahead and screen share this little guy. We're going to make it brief. I got a Q&A. I got, hi, Kate. My biggest fan. This is great. Okay, oh, here comes everybody. So your partner in crime. Yeah, yeah, Linda is definitely my partner in crime. Linda's awesome. Linda's the one to make sure I eat. She brought some plates up the other day. She says, I brought you some plates. That way, you know, when I slide food under the door for you, I feel like I'm in a prison cell. You know, then we can go ahead and, you know, I can just put it on the plate and eat it. That way it fits under the door a little more snugly. So, okay, so let's go ahead and get started because we do have a lot to do today. It doesn't seem like a lot, but it is. So let's talk about, well, first, let's just do the obligatory stuff to get it out of the way. Here's where we are. Thank you to San Diego for allowing us to do this. There's my name. JD stands for juvenile delinquent. There's my phone number. There is my email address. About 20 minutes into this, you're all going to be saying, where's your email address? I will post it again for you. Thank you. Today, we're going to talk about the RLA. And earlier today at 10 o'clock, we talked about how to write counter offers, multiple counters, and backup offers. And whoa, I think we really need to be syndicating this. What do you think, huh? Anyway, y'all were great. I mean, it was just such a great event. And tomorrow morning, we're going to do Glide in the morning at 10 o'clock. And then at 1 o'clock, we're going to do the RPA. So anyway, today we're going to talk about the listing agreement. We're going to be talking about stuff that's going to appear to be legal. All right, I get it. My caution for you is never use that word in a sentence when you're talking to a client, okay? Because you don't want to leave the impression to them that you're giving legal advice, all right? And remember, you have a license to practice real estate. You don't have a license to practice law. So let's make sure that, you know, that we're on track on that. I am a lawyer, not an attorney. I do not practice law. I do a lot of trial work. I hate to say it. I'd rather teach you here. This is called risk management rather than damage control. And damage control is when we got to do stuff to try to get people out of the bind. So not intended to be a substitute for the advice of your broker nor your attorney. Talk to them. There's my email address. If you're not getting the email updates that we send out only one time per week, and there was a boo-boo in this last week's one, I actually had put in the link to take you straight to the one of the webinars, and I forgot to put it behind there, so the link went to the same place. So anyway, it's the only mistake I've made, I think, since 1977, so when I got my real estate license. So anyway, here we are. Send me an email. I'm not putting you on the list unless you send me an email that says, please put me on the list, okay? It's just the way it is. We got a couple hundred people on there. I had, God, how many did I have? 2,300 when I was doing the pitch session, and I think we're going to have to get back to that as well. So anyway, so there we are. I'm going to X out of that, and we're going to get to the task at hand. I'm going to do a new share for you, and let's go to Dodge. I'm going to tell you some stuff today that's going to scare you. So you know, mostly good. Hi, ID. Welcome back. Hey, Betty, you got in. Good for you. Deanne, yeah, look, everybody's here today. Okay, James, all right, good. Okay, so hi, Suzanne, welcome back. Okay, so let's go ahead and get started. We're going to talk today about seller representations. People think, you know what, it's no big deal. You know, now we're in the boring part of the contract. And one of the things that came up in today's class earlier today about, you know, how we get in trouble. We get in trouble when we fill in things. Most of 6, 7, and 8, there's nothing for you to fill in. So as a consequence, we don't read it. You got to read it. It's so important, okay? There are things that are contained in this paragraph that are incredibly important to you, and I'm going to tell you why. And so the scary part's coming here, okay? So, but I want you to pay attention to this, all right? Because we're going to take care of all that. I'm going to tell you, you know, you're either too new in the business to know what to be afraid of, or you're just beyond being afraid of everything. It's just the way that it is. Don't be afraid. Remember, we always say there's nothing you can do that I can't fix unless you shoot and kill your client, and we're going to refer that to outside counsel. So anyway, that being said, let's take a look at my seller representations, paragraph number 6. Let me pull up my highlighter here. because I want to annotate, because you know I love to annotate. All right, so let's talk about this. So seller representation. So boy, most people say, oh, that's pretty boring. I don't need to watch that. I think you do. Seller represents what? Seller represents that, unless otherwise specified in writing, which you know it isn't, seller is unaware, okay? So remember, the standard of care for the seller in California is knew or should have known. So even in your transfer disclosure statement, where you see the questions on the first page and it says, are you the seller aware? Okay, so if you're not aware, you're not aware, all right? But some of the things we're gonna see here in a second, you gotta be aware. Okay, all right, so the first thing, any notice of default recorded against the property. Now I'm going to tell you why that's important. The seller is representing to us that there's no NOD, okay? I'm going to write that up here, no NOD filed. Okay, if there is one, they got to tell us, all right? But this says no NOD is filed. So I'm going to take, and here's why this is important. I'm going to move us to the next screen here, and because the next screen is going to talk about my notice of default purchase agreement. So I'm going to tell you that I've been practicing for 41 years, and I've been aware of this law. It's California Civil Code 1695. I do talks on it. We did a whole webinar on it for SDAR. It is dangerous, 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 and it is a real true law today. I had a situation where I had a seller who I'm sorry, I had an attorney I was having lunch with. Every once in a while, you know, I go, they fed me. I mean, that's always good, right? And I always love it when lawyers buy me lunch. So anyway, I had lunch with this attorney. He happened to be a divorce attorney. We're talking, I don't know how 1695 came up in the conversation, but I'm telling you, this is going to be a big deal for you. And again, my email address is going to become important. I will email all this to you. So the notice of default purchase agreement is the document that you need to be using when you are representing a buyer on a property, and there are certain factors that are going to be involved. And the reason I bring up the divorce was because obviously the husband and wife weren't getting along. They were working on a divorce, and in the course of my conversation with this attorney, he said, "Oh wow, this is pretty good stuff." And he calls me back at the office later in the day and says, "You know, hey, what was that law again?" And so I told him, I said it's California Civil Code 1695. Guess what? The case settled very quickly, and I'm going to show you why. Okay, so this is a CAR's Q&A revised in 2017 because a bunch of things had changed at that time. And this is why this is important to you. You need to make sure the seller tells you, and of course you pull up a preliminary title report or whatever, you know, you always ask your title person, you know, get me any recorded documents because you sure want to know if there's an NOD filed against this property. And here is why. It is actually a crime in some situations just to write the offer. And this is it. Home equity sales contracts, this is what they're talking about. And here are my prongs. I highlighted this for you. Okay, it's called the Home Equity Sales Contracts Law. I teach this in my law class, and you know what? It is just scary. So if the following four things are present, then we need to talk about doing something differently, okay? Property being sold as a residential 1 to 4, which for most of you today, that will be what you'll be working with. You'll be working with 1 to 4s, okay? Remember, a 5 or greater. So civil code is designed to protect the innocent buyer and the seller, and that's in my residential 1 to 4 ratio. When I get into 5 and greater, then UCC, the Uniform Commercial Code, kicks in, and because 5 and greater is considered commercial in California, okay? So the first prong, and all 4 have to be present. First prong, property being sold is residential 1 to 4. Second prong, owner currently occupies the property. The owner is living in it. Number 3, an NOD has been recorded against the property. And then number 4, the buyer does not intend to occupy the property, very loosely defined as an investor. I had a case where husband and wife were buying a property. Husband and wife weren't able to get the financing. The property was a residential 1 to 4. The seller, the owner, was living in it. There was an NOD filed against it, but the husband and wife, the newlyweds, were going to live in it, so the rule doesn't apply. You follow me? They were going to live in it. They were not a non-owner. Okay, well, along during path of progress and all the stuff that was going on, it turned out that the buyer and the seller needed I'm sorry, the buyer, husband and wife, needed a little help getting financing, so they brought dad in. Dad was not going to live in the property. Okay, and so as a result, action against dad for violation of 1695. You see what I'm saying? It can get really, really wicked. So the listing agent, and I'll send this to you, okay? If any of the above hasn't been met, then it doesn't matter. Don't worry about it. But again, you know, husband and wife were fine on number 4, but then when they brought dad, who was not going to live in the property, and then that created a problem. So this is a fairly complicated law. We did a whole webinar on it. If you want me to send you to the webinar, I don't know if I can find it. I think they go away after a couple of weeks. But I'm going to tell you, this is at that point where you might want to have them talk to counsel. Okay, so this is a really good write-up. I really like the CAR attorneys did a great job on this. Okay, and so and I'll help you offline about it. I don't want to spend much more time on it right now, but I will send this to you if you want me to send it to you. Just send me a message to Kevin at Burke Real Estate Consultants. Kate, good. Kate, you got it already. You already know. You know, please send the webinar if I can find it, Kate. Okay. Otherwise, I'll send you the documentation. You can take a look at it. Pretty self-explanatory when you get into it. But it's one of those things. So as the listing agent, you don't have a whole lot to worry about because it's against the buyer for writing the offer. It's not against the seller for selling. So the buyer needs to write the offer with the notice of default purchase agreement, and that's what I pulled up for you a second ago. So when I pulled this up, my notice of default purchase agreement is a form. It's about 13 pages long, and we just revised it in December of 18. But this is the document that you're going to use when you are the buyer's agent writing an offer on a property where the 4 things are present, right? So if you're not representing an investor, if your buyer's going to live in it, don't worry about it. Throw it away. It doesn't matter. Oh, right? Because it only works against non-owner. The idea being taking advantage of someone who it was actually, it was an interesting law because it was passed back in 77 when I got my license, and it said pretty much that, we want to take care of the little old lady that owns the home. The husband has passed away, and the equity purchasers were coming in and buying the properties for the loan amount when in fact the properties were 3-4 times what they were owed on it. So, but taking advantage of people. And we want to avoid that if we can, right? Let's please not take advantage of people. So for use when an investor buyer offers to purchase an owner-occupied residential dwelling against which an NOD has been recorded. So that being said, let's take us back. I'm going to take us back a page. So we're going to go back to here, and now we're going to look at our document, and our document says, seller is unaware of any notice of default recorded against the property. So for you and I, as a listing agent, we're probably going to want to get that from our title rep anyway. We're going to want to get any recorded documents just to see if there's something exciting in there like that, because that can be pretty exciting. And if you have such a listing, and your owner is living in it, and there's an NOD filed and it's a residential 1 to 4. Now, we want to protect the innocent purchaser by putting it in the confidential remarks to the other agent, please use the NODPA, which is the notice of default purchase agreement. Everybody follow that? Real simple. There has to have been an NOD recorded against the property. All right. But again, all 4 prongs have to exist. So residential 1 to 4 probably going to apply anyway. Owner living in it, maybe not. If the owner's not living in it, forget it. The rule doesn't apply, right? The buyer is going to live in it, rule doesn't apply, right? Buyer's not going to live in it, the rule does apply, okay? And then an NOD is a big thing, but that's something you can find right away. So for you as the buyer's agent, be careful when you're writing an offer on a property such as that. Make sure you're using that NODPA, okay? So I was doing a seminar, or actually a live seminar for a brokerage that was doing loans and doing real estate, and they were buying everything around Oceanside and all kinds of places. And when I started talking about this, I thought the broker was going to have a coronary because they've been doing this, and now they needed to kind of back out of it. But the law says you got a problem when you write the offer. So you need to give the seller their statutory notice of a 5-day right of rescission, and that is what is in the NODPA. Okay, so I spent a little bit of time on that. I definitely wanted to cover it. I'm not here to scare you, you know me, but I do want to make sure that you're aware of it. All right, so that was number 1. Any questions? Let me just see if anybody has any questions. questions? Oops, got a couple of them. Roger that. Good. Okay, thank you, Kate. Okay, so that being said, number one was my NOD, NOD, notice of default. Number two, any delinquent amounts due under any loan. So are you behind on payments? Remember, the NOD may not have been filed yet. You can be behind on payments. I've seen people go a long time being behind on payments and still not have the NOD. So, but you'd like to know right away whether or not they are behind on payments or other obligation affecting the property. So you do want to know if they're behind on stuff, because it's going to affect your ability later on to sell the property, right? There are going to be some things, you know, that everybody goes, oh, well, don't worry about it. Buyer will pay enough to pay off any encumbrances against the place. That's not always the case. So you need to know these things up front. Okay, so let's take a look at number three. Are you in a bankruptcy? Now, why is bankruptcy important? Well, I'll tell you what, if they're involved in a bankruptcy, remember when someone files for bankruptcy, there's a 90-day stay. And the 90 days, and we have an attorney in our office who is a broker. He's just a brilliant young man. And he is a bankruptcy attorney. And I have him, we're going to be doing some classes together on some of the stuff, because the short sales are coming. All that stuff's coming. Right now, everything's being held at bay. But a bankruptcy is federal, not state. It's a federal action. And by the way, bankruptcy courts are in process still today, and they're all doing all their stuff virtually. The bankruptcy courts are not closed. They are still going. So once somebody files for bankruptcy, they have 90 days of protection against creditors, but that means a couple of things. One, they can't sell anything during that 90 days, okay? So they can't sell this house. So if somebody says to you, well, you know, we filed for bankruptcy, then you need to find out when, and then I wouldn't, you know, start doing the math. I would say, you know, are you okay if I speak with your bankruptcy attorney? So even our attorney, our bankruptcy attorney, who's a broker here, you know, there are things I know I can talk to him about, and certain things that he's not going to be able to say. And so, you know what, let them be the judge of that, but you need to find out what part of the process they're in. And that bankruptcy is a serious event, okay? Insolvency, you know, are you going belly up or similar proceeding affecting the property? And the bankruptcy very clearly will affect a property where they have an ownership interest in it. Everybody good so far? Okay, looks like we are. We're good. All right, so let's go on. We're going to take a look at number four now, any litigation. So litigation. So we've all heard that term. It says lis pendens, right? So lis pendens is Latin. You don't need to know a lot of Latin to be in real estate, but you do need to know that that means lawsuit pending. So if there's a lawsuit pending against the property, that's probably going to show up with the title search. But remember, again, in the very beginning, you're not getting a prelim in the very beginning. You're just getting a property profile, essentially, which, you know, good luck with that, right? But the prelim will definitely clear it up. So any litigation, and by the way, it may not just be litigation against this property. It could be litigation against the owner. So any litigation, arbitration, administrative action, government investigation, or other pending or threatened action that affects or may affect the property or just the seller's ability to transfer it. All right, so that's a big deal. So I got interviewed regarding Duke Cunningham. Some of you will remember him. I think it was back in 2008, where the DOJ, the big Department of Justice, had filed a lis pendens against his property in Rancho Santa Fe. And so the question was and it was on the market for sale at the same time. And the question to me was, can you still sell the property? And the answer is yes, you can. But here's the thing: you're not going to be able to get title insurance against it. So unless somebody's paying cash and willing to flip the dice and hope that that the DOJ doesn't secure their investment, which they did ultimately, by the way, that'd be a very risky position to take. So the seller needs to tell you these things. And this is why, again, I really think the time you spend with the seller at the time of the listing appointment, all this time you sit down and say, hey, Mr. and Mrs. Seller, is there any litigation? You got an arbitration going on, any administrative action? The time that you spend with the seller on these issues is worth all the time later on. Can you imagine getting 3 weeks into a transaction with the seller only to find out that they can't sell it because they've got this little problem with a meth lab in the basement or something like that? Okay, all right. So important questions to ask people. All right, number 5. Let's take a look. Any current pending or proposed special assessments affecting the property. So just like litigation up here could be common area litigation, anything that affects the seller's ability to transfer the property, here we're asking kind of a similar question: any current, pending, or proposed special assessments, so in an HOA controlled area that may be affecting the property, okay? And so we've seen some significant ones over the years. If you're familiar with Las Brisas in Solana Beach, just south of the post office there on Sierra, you know that they had a special assessment of $115,000 per owner. And I know several people that lost their homes because of it. And so that special assessment can really be something that's going to be problematic. And by the way, please don't count, you need to ask the question, because if you know ahead of time, it saves you finding out by surprise. And if you think that other people are looking out for your best interest, you're sadly mistaken. All right. So, make sure that you find out from the seller, ask the seller if they're aware. If they're not aware, they're not aware, okay? I assure you they were aware of $115,000 special assessment, okay? All right, so those are going to be really important issues, and those are going to be things you want to have that interview with the seller. And as I told you in our winning listing presentation, which I thought we rocked on that one, that was such a great presentation. I think, when I'm interviewing the seller, remember, I always go into my listing appointment thinking, do I want this listing? And most of your top listing agents are thinking that way, not, oh my God, I hope I get this listing. Because if you come on like that, then you're not going to get the listing. But if you come on like, okay, well, let's take a look at this and see if this is something that we're interested in doing. And then it takes on a whole new thing. So that interview, as I said, I always have an interview with my seller. I always have an interview with my buyer. I always spend time with them. And I believe the time spent with those people in the beginning, the very first meeting, I think is worth your weight in gold. Okay, everybody good with that? Real important. Okay. And by the way, folks, nobody does it, right? We're just so quick to email off a listing kit or a buyer's, kit, if you're even doing that. Then, and it's like, well, why don't you spend a little time with your client? Why don't you actually sit down with them, go over things with them, have them sign things? Okay. All right. Okay. Any questions so far? I haven't upset anybody, I don't think. No, we're good. Okay. All right. So seller shall promptly notify who? This is the agreement between you and the seller. In writing, we like the writing part of things. If the seller becomes aware of any of these items during the listing period, or by the way, an extension thereof. Okay. So if any of those things happen, so number one, any NOD. All right. Number two, any delinquencies. Did you stop making your payments? And you know what, folks, I'm going to tell you, sadly, it happens, right? Sometimes your sellers just can't hold on. And if they stop making payments, you want them to tell you during the listing period, oh, by the way, I haven't made a payment. I had one time. I asked them, I said, well, when's the last payment you made? It was in November. It's like, November what? Well, it was November 2017. Huh? You've gone a year and a half, 2 years and not made a payment on your house, and there's no NOD filed. And so, you know what? Hey, don't be counting on that. Remember what I said, you need to protect yourself, and God knows we love our broker. Let's please protect the broker. Okay. All right. So remember, I got my 5 things, got my NOD, I got any delinquent amounts on a loan or any other obligations, bankruptcy, insolvency, anything that looks like that. That's going to slow you down. Any litigation, that's going to slow you down. So notice up here at the top, seller represents that those things aren't going on the property. Okay. Now, why is that important? Because later on, if in fact the seller has those things going on, they might be making the property otherwise unmarketable, and so you may have a cause of action to get your commissions based on bad faith negotiation with the seller. Okay, because remember, when you take a listing, everybody's assuming that we're all being honest with each other, we're telling each other the truth. And folks, I'm going to tell you, from my perspective, it's made the difference in my career. Listen, tell the truth, be ethical, know what the rules are, behave yourself. Okay, everybody good? That's paragraph number 6. I'm going to pop over here really fast just to remind you of what the NODPA looks like. And this is kind of a neat little document. You'll notice that up here, the assumption, oops, can you see that? I think you can. Yes, you can. Okay. So the assumption is, of course, that it is a that it is an investor or a non-natural person. So, the individual, a corporation, a partnership, an LLC, an LLP. So something other than someone who is going to live in the property. So it could still be a natural person who is going to live in the property, but then this wouldn't apply, right? But if it could be a natural person who is not going to live in the property, then the rule is going to apply. And you need to know to use this notice of default purchase agreement, okay? And again, I'll see if I can scrounge up. Oh, you know what? You can look it up under past webinars. You can go to SDAR. It's also on YouTube. And I thought we knocked it out. We did a really good job on that. I mean, that NODPA is a big deal. So those are probably some good ones for you to take a look at. It also probably take a look at the ones on the TDS and those things, okay? All right, if everybody's okay, I'm gonna move us forward now to paragraph number 7, and brokers and sellers' duties. And so I always love this part. And my favorite part, of course, is getting paid. But, at the end of the day, I love the part where we actually talk about what our responsibility is to each other. And here's why. Because I'm going to do what I said I was going to do. And I'm assuming you, Mr. and Mrs. Seller, are going to do what you said you were going to do. And if you don't, my broker's probably going to come after you, because you know what? Listen, we were all being nice to each other. We're telling the truth. Nobody's lying. Everybody's good. And so we want to make sure that we behave that way. And the sad truth of it is that, in the old days, we shook a hand and we had an agreement. And today we have to have things in writing. And so that's where this is all coming from. Okay. So number 7, my favorite word, duties. Okay. And remember, I told you in a previous webinar that someone's duty is really a decision for the trier of facts. So the judge will make a decision whether or not somebody had a duty to do something. And even in my trial work, I don't use the word duty. I mean, I might use the word obligation, but I'm not going to use the word duty, because duty is a term of law. Okay. All right. So watch out. It's kind of like breach of contract or damages or remedies or some of these other words that, you see that sound really cool. Be very careful about using, excuse me, be very careful about using. Those are fairly legally charged words. Sorry about that. Every once in a while, I got to grab a water. Okay. All right, so let's take a look. Paragraph number 7A, broker agrees to exercise reasonable. Now remember, there's that reasonable man standard. It's a standard of law. Somebody sent me a thing earlier today saying they had contracts in law school. So you know exactly what I'm talking about, the reasonable man standard, okay? So that's just, again, another term of law. So broker agrees that we're going to exercise reasonable efforts and due diligence. We're going to do what we're supposed to do, okay, to achieve the purposes of this agreement. So this is the quid pro quo of the contract, okay? Unless seller gives broker written instructions, so express instructions to the contrary, broker is authorized but not required, okay, to do what? So let me get rid of some of these little red things. And this is a paragraph I have a hard time with, and I'm going to show you why in a second. Okay, so authorizes, so the broker is authorized but not required to do what? Order reports and disclosures, including those specified in 7C. Here's C, okay, as necessary, all right? Now, what would those reports look like? So I'm going to go down now to 7C, and I want to take a look at this. And so this paragraph came out of our removal of the wood destroying pest addendum from the purchase agreement back about, I guess it's been about 10 years now. We got rid of it. Hopefully you don't even know what it is, but it was a nightmare for us because what? It was a form that says the seller agrees to do section 1 work. It's essentially laid out who was going to pay for work, who was going to pay for report, and then who was going to pay for work. And so as a result of that, lenders kept calling us out and making it get done as part of the contract because we had made it part of the contract. And so in Northern California, that's what they did. They ordered a termite inspection at the time of the listing. I'm sorry, not a termite, a pest inspection at the time of the listing. Well, remember, now you've got the seller investigating their own property. And I thought my memory was that the seller doesn't investigate their own property. And I'm saying this facetiously because the answer is the seller has a duty to disclose what they knew or should have known. It's the buyer's duty to investigate. Okay, so by law, the buyer is held to a standard that, I've had cases where the buyer said, well, wait a minute, now I just figured, the seller is going to have to tell me whatever they need to tell me, and I shouldn't have to do any inspections or anything. I'll just rely on what they said. And so your contract is full of language that says that the buyer will not do that. The buyer has an obligation, the buyer has a duty to do their own investigation of the property. So when I write out my notes, when I do my classes, the seller's duty is to disclose, right? Disclose, sorry about that, I'm writing at an angle here. The buyer's duty, I'm bound to have this explode. The buyer's duty is to investigate, okay? And then who's left? Number 3, the agent's duty is to do a what? Reasonably competent, diligent, visual inspection of the property. Wow, what a novel concept, right out of the Strasburger case. So literally, you can go to your transfer disclosure statement, TDS, page 3, paragraph number 4, top of the page, and it says that the listing agent has done a reasonably competent, diligent, visual inspection of the premises. Any real estate attorney out there knows that language. They've got it memorized because it just comes up all the time. Make sure you keep these duties separate. Okay, number 1, seller discloses what they knew or should have known. Number 2, buyer investigates the property. And then number 3, the agent has to do a reasonably competent, diligent visual inspection of the premises. So knowing all that, why? Sorry, I mean, I'm at odds. The attorneys at Sierra look at me and they go, yeah, we know. Okay, well, this came about because when we got rid of that form, now the people in Northern California said, well, that's not how we do business. And of course, they threatened to secede from the union or something. And so they had this put into the contract. And I can tell you a specific individual who did that. And I think he's brilliant, but he's not brilliant on this topic. Okay, so bottom line is, why is the seller ordering investigating their own property? And that's what this paragraph does. Order reports and disclosures. And frankly, we won't do it. When we take a listing, seller looks at that and says, well, what are you going to order? And we go, we don't order anything. But they put it in the contract that says that you can authorize us to do it, but we're just not going to do it. So I don't know what you would do. But bottom line is, down here under 7C, it gives me a list within 5 days of the beginning date of the contract to pay for the following pre-sale reports. Give it a nice little name, maybe my structural pest control, maybe my general property inspection. Oh boy, here we go. Okay, well, why'd you stop there? Why didn't you do a manometer inspection? Why didn't you do a soils investigation? You see what I'm saying? So, once you start down this path, you're going to have a problem. So I think that, why did you limit it? And that's what the attorneys say, so, okay, well, why did you limit those things? When oh, shoot, I got rid of everything. Sorry. Why did you limit it? Why did you stop at structural pest control? Why didn't you order the property inspection? Why didn't you order the, take a look at your BEI, folks, your buyer's election inspection form from the SDAR risk management library, pages of inspections that the buyer could be doing. And so the answer in court is, well, why'd you stop here? Okay, so again, this is why I have a problem with this. Why are you ordering the HOA docs? You're going to pay money for the HOA docs, right? And then what's going to happen? The escrow company and the buyer are entitled to certified copies, so you got to order them again. And so I think you're spinning your wheels. Everybody good with that? Good. I haven't upset anybody yet. Okay, good. So I'm going to get rid of those. But anyway, so that covers me up to a little I, and we just got rid of C. So now order reports and disclosures, those necessary. Then we're going to talk about advertise and market the property by any method and in any medium. Okay, so guess what? That's really good news for you, right? Does anybody put anything in the newspaper anymore? Why would we want to limit what you were going to do? Why not, in fact, you actually be able to have pretty much carte blanche. You can put it almost anywhere you want. You're going to put it on the internet. You're going to put it on in the rag. You're going to put it in the local paper, or the La Jolla Light or something like that. Those are things that you are able to do. But that's what you're claiming you're going to do: advertise and market the property by any method and in any medium selected by the broker. including the MLS and the internet. So in other words, you make the decision on what you're going to do. Now, I would advise you that if you're on a listing appointment, you have maybe a list of some of the things that you have done. We used to run full page ads in the UT. It was only, what was that, $30,000 an ad? We would run that. I mean, my small group would do that. God, the amazing the number of hits that we would get off of that. And then today, of course, you have this relationship already because you're with SDAR, and we have a relationship with the UT. So you've got lots of stuff happening in that direction. Okay. All right. So, and to the extent permitted by those media, control the dissemination of the information submitted to any medium. So in other words, we have some control when we put the property in the multiple listing service, or when we advertise the property on one of those third-party aggregators or syndicators. When we put that out there, we've got some control at that point, but we're not going to probably have that control, a year from now or 2 years from now. Okay. And then finally down in here, and disclose to any real estate licensee making an inquiry, the receipt of any offers on the property and the offering price of such offers. And that was a great question. It came up today. Who was it? It wasn't Deanne. You weren't there for that one. Somebody asked me the question today. I'm trying to think of who it was. It was a really good question because, I made the comment in there that, in January of 2008, the National Association of Realtors changed their model rules to say, okay, you think that the clear cooperation is an issue? Well, boy, that was a huge deal back in January of 2008, where it said that the listing agent, with the permission of the seller, here's your permission, with the permission of the seller, may disclose the content and terms of competing offers to competing buyers. So you get 5 offers on the property, you can tell, you're the listing agent, you can tell all 5 of them what the other offers are. That's huge. But I still have people that say, oh no, it's against the law, you can't do that. No, I'm sorry, it's not against the law, and I might know, okay, but that's because we're still operating from, 12 years ago. But in January of 2008, NAR changed its model rules and said, you have the ability, with the seller's permission, here's the permission, okay, to disclose the content in terms of competing offers. For those of us who've been around for a while, we're like, what the heck, man, we never were able to do that. That's confidential information. Not true, not anymore. And the theory behind it was that that's the best way for you as the listing agent to be able to build up, a higher offer for the seller by telling other buyers what the different offers were, right? I mean, we used to play games when we were, it's like, you're getting warmer. And then finally, we just say, hey, you know what, bag that. It's in the seller's best interest for the listing agent and the seller to be able to tell the buyers of the other offers, so we're not playing this little game back and forth. Okay, everybody good with that? I like it. That's the answer to the question, and I think I said today that we'll be covering that later on today. Okay, and that's what we ended up doing. All right, any questions on that so far? No. Okay, good. Okay, now paragraph number 7B. Seller agrees to consider offers presented by the broker. Remember, folks, you have an obligation by law to present all written offers to the seller, okay? And by the way, all the way up until the seller no longer owns the property, okay? Whatever median that is, okay? So seller agrees to consider offers. Let me get rid of my keyboard here. So seller agrees to consider offers, all right? If seller sits back and says, I changed my mind, I don't want to sell it, I don't want to look at offers, you're going to have another problem, okay? That's going to be something you have to deal with. So presented by the broker, and to act in what? Good faith, like that word, good faith, and to accomplish the sale of the property by, among other things, making the property available for showing at reasonable times, and subject to paragraph number 3F, referring to broker all inquiries of any party interested in the property. Okay, so again, good faith, big word, all right. Bad faith negotiation, you might have heard of that before. That's certainly something that you don't want to be accused of, but the seller agrees that they will consider whatever offers that you bring in, okay? All right. And again, remember, cause of action by the broker later if the seller refuses to do that. So make the property available for showing. And then here's my reasonable times, okay, my reasonable man standard. And then, of course, the seller has agreed in the previous paragraph in 3F that they'll let us know if anybody inquires about the property. So, somebody's leaning over the fence one day and says, hey, I'd be interested in your property. And, well, I've got a listing with somebody else. Why don't you wait until the listing expires? We're going to have some breach issues and things like that when that comes up, okay? Everybody good? All right, questions? No questions, okay. All right, let's see. Seller is responsible for determining at what price to list and sell the property. And so we frequently say this, that you do not have the power. You have the ability to recommend prices, but we want to make it very clear that it is the seller's choice, the seller's decision on what to list the property for. And it's the buyer's decision, the buyer's choice on what they're willing to pay for the property. But we want to be really clear that it is the seller who determines the price to list it for. And then later on, when the offer comes in, the seller determines what they're willing to sell it for. You're not a party to this unless you have an ownership interest in it, which you better make sure you're making those disclosures really clear. Okay, everybody good? Okay, so it's real. So these are some of the tenets that we have that are, like, I know it's in the contract someplace. Yeah, it has to be in the contract someplace. We have to have told the seller, hey, you're in charge of telling us what you want us to get for the property. Our job is just to advise a good figure. Okay. All right. Okay. I'm going to go to C. Okay, moving right along. C, investigation. I'm sorry, we already covered it. I'm going to kill it. C doesn't work. Do whatever you want to do. Again, follow the advice of your broker. Do whatever your broker tells you to do. I just think that if the seller didn't know, and now you order an investigation of the property that produces information now that they do know. So like I just had this happen, a transaction did not close escrow. The buyer had done a physical inspection, put in a request for repairs. And so the broker told the other broker, okay, well, now you know that if we can't come to an agreement, you have to use that inspection report, not necessarily the request for repairs, but the inspection report. You need to give that to the next buyer as a disclosure. And so, you know what? Yeah, I'd say yes, you do, right? Because you're aware of it, you have constructive knowledge of it, you got a copy of the report. So yeah, you're going to have to produce that report for the next buyer. I think so. So definitely talk to your broker about that. Definitely be very careful about when you don't disclose things. In the immortal words of Pete Zalecki, they don't sue you for what you told them. Okay, they sue you for what you didn't tell them. All right. Okay, so you remember, if you've ordered a report, I don't know why you would order one for the seller, but if you did, then that becomes knowledge that you have to disseminate to other buyers as they come along. Okay, all right. But if seller didn't know about it, then the seller didn't know about it. Seller was not aware. The seller was not aware. Okay, that being said, let's go to number D. Seller further agrees to indemnify. So we've all heard this. Indemnify, okay. I would be careful about writing. I see agents write this language out. It's like, yeah, I know it sounds really cool. Let the lawyers write it, okay? So defend and hold the broker harmless. Okay, so in other words, you're going to cover my cost of defense, Mr. and Mrs. Seller, from any claims, all claims, disputes, litigation, judgments, attorney's fees. You're paying the bill, and costs arising out of what? Let's see what that looks like. Arising out of any incorrect or incomplete information supplied by the seller. Okay, now how do I confirm that? When I take my listing, didn't I tell you in the listing presentation that we did, all right, I take the listing input sheet with me. And at the bottom of the listing, page 8, at the bottom of page 8, it has a place for the seller to sign. So in other words, I'm going through the house and I'm checking boxes and I'm asking questions. The seller's giving me all this information. And then the seller looks at the form and they say, yep, all this is accurate, and then they sign it. Okay, so now for sure I've got the proof that I was talking to you about in that class that says, if I get incorrect or incomplete information, then I'm not the one that discovered it. It was given to me by the seller. So remember, be the source of the source, not the source. And so that's what you do. You always want to refer to the source. So the seller says, The county says, those are the kinds of things that you need to make sure that you're doing. Make sure that you send them to that source. So if the county told you what what the seller can do with the property, then maybe you want to have the buyer go to the county to get that information and not rely on you relaying information. This is a very good example of when, yes, you do shoot the messenger. So please don't get yourself into that trouble. So any incorrect or incomplete information, the seller agrees to hold you harmless, or, big or here, from any material facts, also came out of the Strasburger case. So any material facts, and so as you remember from the seller's duty, disclose any material facts affecting the value or desirability of the property, came right out of the court case. Okay, so material, what's material? Material is, it's another one of those terms of law that says whatever would be material to the reasonable man standard. I was like, come on, why don't you give me the answer, right? Okay, so it's kind of like hiding the ball in law school. So what's material? I don't know. What's material to you might not be material to me. So it's kind of being elusive. It's like sticking a pin in Jello. Okay, all right, that the seller knows but fails to disclose, including dangerous or hidden conditions on the property or animals or things like that, right? So if the seller's aware of it, or if they provide incomplete information or inaccurate information, then they agree to pay our cost of defense. Okay, so paragraph number 7 is a really big paragraph. It's right up there with paragraph number 5 and 6 on the BRE. The BRE is the buyer representation exclusive agreement. And so in paragraph number 7, we're talking about duties, and 5 and 6 in the BRE, we're talking about duties and obligations, same kind of thing. Okay, everybody good? Questions? That was a lot of material. Seeing none, I'm going to go further here. I am picking up. It's interesting. We're rolling through this. Hi, Robertson. We're rolling through this, and I'm picking up people. So, okay, all right. Well, hopefully you didn't miss too much of it. So let's go ahead. Let's take a look at paragraph number 8. And here we're going to talk about paragraph number 8, and I'm going to head into paragraph number 9 a little bit, even though number 9 is going to be in next week's session. But let's talk about number 8, and here's why. We have changed our way of doing business. It was a huge change. It was not that long ago, probably 5 years ago. Paragraph number 8 is the paragraph. You remember this from the state exam. What document provides for the broker being able to accept a check on behalf of the seller? Okay, so remember that in the old days, the buyer would produce a check, and then the check would be given to the broker, and then the broker would, to the agent or to the broker for the company, and then the broker would then put it into the trust account, and then that's where all that broke loose. And here's why. Well, first of all, I tell you, I've been doing this a while. We have people losing the check. We have people having the check made out to them. We have people having the check blank, right? So that, they just have the buyer sign the check, and then the agent fills it out when they come together with a, contract, puts in the amount and puts in the escrow company or whatever. It's like, oh my God, you're completing a document over a signature. I think that's fraud. I think you can go to jail for that. And I think I know there's no E&O coverage when you break a law. So that's a problem. Somebody has a question. Let's take a look at this. Okay, so structural pest control, lender requires, have you ever had the buyer pay for this? Okay, so Betty, so there is no law. Remember, the law in California says that the sales of real property are in their present as is condition. So therefore, no duty by law for the seller to do any repairs to a property. Okay, buyer's buying it as is, okay, as is present condition. So the seller still has by law an obligation, in California at least, California now, an obligation to disclose material facts affecting the value and desirability. That's all. There's no requirement to do a structural pest control. The buyer, under paragraph number 12, and we're not there yet, but the buyer has the right to do it. Okay, and the lenders don't require it. It's a common misnomer. So some lenders require it as what we call an overlay, which means that the lender itself doesn't require it, but when they're going to go sell the package, they make it like a personal requirement to them. My advice is that that's very 80s. I'm not telling you what to do. I probably wouldn't work with the lender that required it. And God knows people jump from lender to lender all the time. And we have transactions, we never have pest control. We close the deal, everything is done, and the buyer can order a pest inspection during the transaction, paragraph number 12 of the RPA. They can order a pest inspection, but there is no law that requires an inspection. Okay, and there's no law that requires a clearance. And then some people come back and they'll say, well, the VA requires it. I don't know. I read the VA lender's handbook, and the VA doesn't require it. What the VA does say is that if their inspector, if their appraiser, who is a mini inspector, goes out and sees some kind of evidence of some dry rot or something like that, then they can request an inspection. So this is where we backfire on ourselves, because they can require the inspection, but remember, in the VA, the buyer's not allowed to pay for the inspection. It's $75 or whatever, but the buyer can be made to pay for the work, and that's where we shoot ourselves in the foot. So be careful about how you do that. I think I missed 7D. James, did you? Let me, goodness gracious, did I, 7D. No, we covered 7D. Yeah, there it is. Indemnify and hold harmless. Okay. All right. Next page. Betty, did I cover you on that one? Let me find your question again. So structural pest control, lender required. So I don't know really any lenders anymore that do require it. I think Mission Federal, maybe, whatever. We're just not going to use them. So, but there's no law. The law says you can't, so this is why the WPA form was a real problem for us. The WPA was a form that had the seller agreeing at the time of contract to do the work. And so I had a court case on that. I had a great lawsuit on this. I mean, I'm sorry, I get excited about lawsuits, but it's because, you know what, the person wasn't using their head. So here's how it works. The buyer, it turned out it was a dual agency situation where the listing agent ended up representing the buyer as well, and they owned the brokerage and they were an attorney, and so they used that WPA form. It committed the seller to doing the work without knowing what the work was, and so what ended up ultimately happening was the property, it was a $750,000 home. The inspection came back with $15,000 worth of repairs. The seller said, I'm not going to do it. The buyer held up the WPA and says, yes, you are. You signed this document that says you will do it. And the seller then said, I'm not going to sell you the house. And then the buyer held up the purchase agreement and said, yes, you are. I've got a purchase agreement with you. And of course, then it came to me and I referred them to counsel. And it was $70,000 later. So the seller literally gave the buyer 70 grand to go away. Now you wonder why it was only $15,000 worth of work. They were just determined that they weren't going to do it. And by the way, they sued their broker. So it's a principle of law called joinder. They brought the broker into it. Broker coughed up 20 grand to buy out of the lawsuit, and because there's no law, right? And they just assumed there was and there wasn't. It's just, that's the way everybody always did everything. And so ultimately, at the end of the day, why would the seller pay 70? Why not just pay the 15? But the reason was because the property had gone up 150 grand during the time of the litigation. And so the seller said, we can give you 70 and we're going to make another 80. Buyer was happy. They got 70. And so, and they ended up going off and buying another home. So, so be careful about that. Be careful about some of the things that we think we know. There is no requirement by law to do any work on a property. There is for the seller to do any work on a property. There are some code items like smoke detectors and things like that that are required by law, but it's not required that the seller do it. So that's all that means. Okay, so. Yes, Betty, I'm full of all kinds of interesting information. Okay, so back to my paragraph here. And I'm sorry, anybody else have anybody got anything in there? No. Okay, so back to my paragraph number 8. So the deposit, as we're going to discuss it, this is the part that the broker is authorized to accept and hold on the seller's behalf any deposits, whether they're at the time of offer or whether they come in later as an increased deposit. And so as we know, in Southern California at least, we usually give the money over to an escrow company or something along that part. But here's what was going on. And I mentioned it earlier, all the crazy things that happens with deposit checks. And so, I've been management at 3 of the largest brokerages in town, at the time, the largest brokerages in town. And I walked into one of them, and here's the trust log sitting in the kitchen. It had to be 3 inches, 4 inches thick. And I'm looking at it, I'm opening it up, and I'm going, here, we got hot checks in here. Hot checks, you know what I'm saying? I mean, they're live. Well, the transaction didn't come together 3 months ago. The check is still there. Then we had current checks, and then we had copies of checks. There were so many things in there. So this was a good example of a problem that was created for brokerages, and that is that the trust log was rarely handled properly. And so we literally had a door drilled in. We had a hole drilled in the door to the bookkeeper's office, so that people, when they came in, could drop the check into the office, because it needed to be secured. And so, like on a weekend, you're coming in, and remember, your trust log needs to be in chronological order. It's the first thing that the DRE looks for when they walk into your office. They say, "Show me the trust log," and all those entries better be in there. Okay, and so created an amazing problem for us, because most of the time it wasn't. So Friday afternoon, you put a transaction together, you don't go into the office until Monday, but then when you get into the office on Monday to enter this into the trust log, now you're entering in stuff that shows a date, that was before the entries that are in there. So, it didn't make any sense. So now you have the chronology is way off. And guess what? Brokers are losing their licenses for that. So we just decided as an industry statewide that we wouldn't take the check anymore. So we created that language in the contract in the RPA that says, the initial language says that the buyer will get the check to escrow or to title or to whatever third party is going to be responsible for handling it. But we don't touch the check, and we changed the whole world. And I can tell you that the Department of Real Estate, when we first came out with that in our purchase agreements, the DRE said, "Oh, you can't do that." I mean, it was 6 months before we convinced them finally that, you know what? We don't want the check. And they came back and they said, "Well, we get it." Because remember, we've been trained in real estate that the check is actually my what? Now I'm going to lose the word for it. Not compensation, but starts with C, consideration. So my check is consideration. Well, that's not true. The law says that consideration is an exchange of promises. So all you really need is, I agree to buy your house if you agree to sell it to me, not the check. The check becomes another thing. So I agree. We like a big check. We like something that shows that the person's serious. That's why we used to call it an earnest money deposit, but it wasn't necessary. And so this paragraph is from the rule that says, somewhere along the way, remember, this is the employment agreement, somewhere along the way, seller has to authorize somebody to receive checks on deposits on their behalf, whatever that is. So we left this paragraph in here, and on the off chance that somebody would actually collect a check. And you'll see that language in the RPA as well. You'll see that the language in there in paragraph number 3, at the top of paragraph number 3A, says, the first item in there is that the buyer will bring the check directly to the service provider within 3 calendar days, right? 3 business days in that case. And then the second paragraph, B, underneath it says that the agent has taken a check, and that's the language from the old contract. And I had actually lobbied to get rid of that. And then Neil Kalin later on, when they finished the form, they said, "Yeah, we know, we talked about getting rid of it, but so just be our luck that some real estate agent in California will take a check." And so we need to at least provide for the language that says this is how that check is going to be handled. And it does. It says it in the RPA that the check shall be an original check, not a copy, and it needs to be given to the broker. It needs to be entered in the trust log, folks, and just we're never seeing it. And so just here to save you a lot of grief. So that's kind of the history behind the deposit. That's the history behind paragraph number 8. That is your authorization to accept checks on behalf of the seller. And again, state exam question. You won't see it on a renewal, but you will see it on a state exam, okay? So anybody have any questions about any of that? Looks like, I always like it when somebody says very interesting. I often think of Sergeant Schultz. Very interesting. Okay, all right. So that being said, I'm running out of gas here. We are going to next week. We are going to talk about agency, and so that's my specialty. I do standard of care, standard of practice for real estate agents, and agency relationships is one of the most important things that we're going to discuss. And it essentially tells everybody, and handled differently, by the way, in different states. And I teach in other states as well, as you know. I can tell you California, I think, is cutting edge. And I like the way that they do it, but as you're going to find, there are a lot of different ways to do it, but you need to make sure that you do it the right way. So the assumption here, without going into next week's assignment too far, the assumption is that we are going to make sure that we have had the seller, we have given the seller the agency disclosure form, and you know that it's concluded kind of like in part of a template now, the agency disclosure, and then you have your PRBS, which is your possible representation of more than one buyer or seller, and then you have your wire fraud advisory, and all these things that we just know you need to give your client before you start going down that path, to protect your client from the bad guys out there, at the same time to protect yourself from your client. And I think we have to remember that when somebody gets hurt, everybody's going to be looking at you because you're the guy, your gal making the most money in all this, they think. I mean, it's not true. The seller's usually making more than anybody, but that's what's usually going to come out. So questions about any of that? Questions? Thanks a bunchies. Okay. All right. So thank you, Kate. So tomorrow morning, remember at 10 o'clock, we'll be doing a presentation on Glide. I'll only have an hour to do it, but it'll be fun. You'll enjoy it. Glide is a program that I was successful in working with the company Glide. With SDAR and getting it as a member benefit at San Diego. So it's really kind of neat because, CAR had just given up the gas on signing, filling out forms and signing things. We didn't want the agents filling out the TDS. We didn't want them filling out the SPQ. Those are things the seller has to fill out. Well, then Glide came along and said, we can make it so that it's secure so that we know it's gone to the seller to fill out and the agent's not filling it out. Those were some big disclosure items. And so we'll talk a little bit about that in the morning. That'll be at 10 o'clock. And then at 1 o'clock tomorrow, we'll launch into the RPA. And I don't even know what paragraph we're on, but it'll always be good, I promise you. So, oh, Deanne, are you using it? Yeah, Glide's a good little program, right? I had it since it first got created. It's a neat little deal. I remember negotiating it sitting at a restaurant in Monterey, actually, quite a few years ago. I guess I can now timestamp that. Excited to hear any tricks. Yeah, I'm all about tricks. So any tricks that I might have. Thank you, Deanne. Yeah, neat little program. We'll play around with it tomorrow. We'll get good at that. But again, in the afternoon, but why Glide over normal zip forms? Well, James, we do zip forms on the first Thursday of every month. So next week on Thursday will be the first Thursday of the month, and we'll definitely be talking about zip forms. And if you can do me a favor, because I've been doing it mostly as a basic class so far, if you can send me ideas or questions that you might have, I can why use Glide? Because CAR, as I said earlier, CAR just kind of gave up the ghost and stopped. It costs them a lot of money, when they're because they pay DocuSign, money. They pay ZipLogix a lot of money to tag the forms. And so, like, even for us at San Diego, when we have forms, if we want the agent to be able to fill them out in zip forms, we're paying like 90 grand for our library, and it's a lot of money. And so, because it costs them money to produce it. So we CAR just gave up, and they just said, we just can't, they're changing the form so much that it just got too cost prohibitive for them. So now Glide came along and said, we'll do it for you. And they've done a pretty good job. I'm impressed. And of course, SDAR grabbed onto it right away as a member benefit. So you have a member benefit that a lot of other people don't have. I recommend that you get good with it, use it, play with it. But that'll be our morning thing. So we'll be doing that at 10 o'clock. Next week, we'll be doing zip forms again. So Glide forms are not available in zip forms. Oh yeah, you're going to use the forms in zip forms in the Glide program to fill them out, just like you would in zip forms. You would send them either through digital ink or you would send them through DocuSign. So I know we got hit with a bill by DocuSign the other day. Our brokerage did. They said, well, you're paying for the broker's account. I don't know, we're paying like $300 a year or something for the broker's account. And they said, but you used 586 packages. We do a lot of transactions, right? So 586 packages. They said that was a little more than we thought. Anyway, it's pretty funny. We're still not going to pay them more money. In fact, we're probably going to stop using DocuSign. We'll probably start now and use the digital ink platform because it's really, since Lone Wolf purchased zip forms, the digital ink platform has gotten better. Digital ink is actually currently running it's actually AuthentiSign. So now we're calling it Digital Ink 2 because it's a new platform. It's working a lot better. But AuthentiSign is the big picture. AuthentiSign is a company owned by Lone Wolf. So stay tuned for that. We'll talk a lot about that tomorrow. That's all I got for now. Any other questions? Galena, thank you. Look forward to seeing you tomorrow. Thank you, Galena. It's always good to have you here. Thank you again. LJ, thank you. Thank you very much. I look forward to seeing you all tomorrow, assuming there aren't any more questions on any of this. This was kind of a shorter one than normal. So anyway, I just want to make sure you're all good. Thank you all for being here. And again, I look forward to seeing you tomorrow. Take care for now. Bye-bye.